are very fortunate today to have two terrific attorneys from Fennemore Craig who graciously brought themselves here to answer some of these questions and to give you tools so that you can practice your business and serve your clients well. Bruna Pedrini served as chief counsel of the Civil Rights and Conflict Resolution section of the Arizona Attorney General's office. She's helped builders, developers, colleges, restaurants, large sports and entertainment venues, and hotels comply with federal, state, and local requirements and represents them in ADA and fair housing litigation. Alexis Glascock has worked in private practice as well as in state government. She has served as counsel to the president of the Arizona Senate and assistant to the general counsel of the Legislative Council. She has experience drafting and modifying legislation. She gathered experience at the federal level with the majority leadership of the Joint Economic Committee of the U.S. Congress. In that role, she selected witnesses to testify before the committee and authored a 3-volume series on the economic impact of women in the marketplace. So please help me welcome Bruna and Alexis. This hour, we're going to be discussing ADA.
ADA.
Really? Okay.
And to start us off,
Where does that go?
1 second, I need to grab one thing.
we're going to start in just a moment. And when we do, Alexis has said that she will open it up for us by giving us a quick little primer on ADA and how that legislation happens and how we might have opportunities to influence, impact the change in some legislation, either locally or state. So this is going to be really interesting to see how we can make a change in some of this since we're so impacted and so are our clients. So Alexis?
So what I'm going to start off with is just a general overview of how a bill becomes a law, and some of you probably remember from high school how that all takes place. But I want to just briefly go through the process, and then I'll explain what's gone on with the ADA. But the point is that there are opportunities for you as an association or as an individual to have an impact at both the state level and the local level by trying to get ordinances changed or state laws changed that could help you in this area. So basically, in terms of how a bill becomes a law is about this time of the year, people start meeting with their legislators from now all the way through the end of December. And the legislative session begins in January, the second Monday of January. Typically goes through the end of April, beginning early May, but sometimes later it can go till July or August. In bad years, we've had that happen, where there's been difficult issues with the budget or whatnot. But so basically, you have an idea, and you meet with a legislator, and you want them to help you with sponsoring a bill. And depending on when I represent clients, I try and bring them to legislative members who chair a committee or who are in leadership in the House or the Senate, because I want them to shepherd my bill through. And it is a Republican-dominated legislature at this point in time, and has been for quite some time in our state. But so typically I'm working with, I'm going to always work with the majority members on getting a bill sponsored. So if it's something that's, affects your whole industry, we would try and build a coalition. You want to get other like-minded groups together and other stakeholders. And I try to vet the issues so I know ahead of time what are going to be the likely concerns and deal with them in developing the legislation. And we also do that in conjunction with the governor's office to make sure that they're on board, because that's the final step. So you want to make sure from the beginning that everybody is as happy as they can be with the bill. Basically what happens is you introduce a bill in the House or the Senate, and it's assigned to committees. So typically it's assigned to 2 or 3 committees. The fewer the better. And it's always assigned to the Rules Committee. So say in real estate, it's assigned to Commerce. So the Commerce Committee will take testimony on that hearing, and all of the members vote, and members from your association might come and testify, other people who are affected by the proposed legislation. They vote on the bill. If the bill passes, then, and it's assigned to another committee, it has to pass however many committees it's assigned to, and say it starts in the House, it passes out of those committees, it then goes to the Rules Committee to make sure it's constitutional. Assuming it's constitutional, it goes to one of 2 floor votes. The first floor vote is the Committee of the Whole, and that is not a recorded vote. It's a yay or nay vote. And at that time, amendments can be added in. So say there's a bill you're working on and somebody else says, well, I'll support that bill, but I want you to make these minor changes. It's already out of committee, so it has to be amended on the floor. So that's an opportunity to fix the concerns of stakeholders, or maybe something's come up that you yourself realize should be in the bill, so now you're adding that in. It has to be germane, all the same topic. So as soon as that is passed out of committee of the whole, it then goes to a third read or a final vote. And at that point in time, it is a roll call vote, and you know how people have voted. And then it switches houses, and it's again assigned to committees and goes through that same process in the other house. All along the way, you're trying to make sure that all the members are supporting the bill, and you're constantly trying to find out any who are opposed to it, because you don't want any surprises when it's down on the floor. But that's basically the nuts and bolts of how a bill gets passed. So with that in mind, I'm going to talk about the ADA and what happened in Arizona on the ADA. I'm also going to talk about it at the federal level. So basically, Arizona is now in the forefront of having legislation passed on this topic, but it's also been introduced, the American with Disabilities Act. Let me first set what gave rise to this legislation in Arizona and what's going on at the federal level. In certain states that adopted, states had to adopt the American with Disabilities Act. So Arizona has the Arizona American with Disabilities Act. Our statute does not directly mirror the federal statute, as does other states have the same situation. As a result, under the federal law, you cannot receive damages. You can't get punitive damages or attorney's fees. But under Arizona law, like other states, where it's not specifically prohibited, it's left open. And so until a court said it couldn't happen, or the legislature says it can't happen, they're available to people who bring suits. Consequently, those states that have laws like that have more litigation. In Arizona, there were two plaintiffs' attorneys, and one in particular who was really a vexatious litigant, and he filed thousands of suits. And Bruna can chime in because she really is the expert, one of the top people in the state on this whole subject. But they filed suits, over 1,000 suits, which the Attorney General consolidated and eventually dismissed. But during the pendency of this, what the plaintiff was doing, first they were doing drive-bys, where they would go to parking lots and they would look for parking lot sign violations. And so if the striping was not dark enough, or the width wasn't wide enough, or the sign wasn't the right height, and these regulations have been changed from when they originally passed. So, or not changed, there were new regulations passed dealing with the parking lot signage that hadn't previously been there. So people who had built their parking lots prior to these changes were not in compliance. In fact, the plaintiff attorney who brought most of these, the news team went to his office and his signs were not in compliance. But nonetheless, I know, pretty horrible, but true, his were not in compliance. He was sending people to these parking lots. He would send disabled people who would go, or not even be disabled. They would do a drive-by. They would not get out. They would do a drive-by and say, oh, it's in violation. We're either going to send you a demand letter and try and get you to settle, or we're going to sue you. We're going to send a demand letter and sue you. It then grew. He started doing Google searches. And so entire zip codes were literally blanketed with demand letters. And there are instances where vacant lots, those owners were served with a demand letter saying you violated the ADA for your parking lot not being in compliance. I mean, it was really pretty horrific. So as a consequence, the Attorney General, as I mentioned, got involved and consolidated the cases and ultimately dismissed them. But nonetheless, the plaintiff continued on, and I think he's now in Las Vegas. But in reaction to all of this, I'm now going to talk about the Arizona laws. In reaction to all of this, last year, the legislature, the governor, the Arizona Chamber, the Phoenix Chamber, a lot of business organizations decided something had to be done because small business owners who wanted to try and remedy the violation didn't have the funds to remedy it because they're trying to deal with a lawsuit. So it really sort of caused everybody to just be in a panic. How do I take care of, the parking lot issues? Or now they've come into my my shop, and I've got other issues, and so I'm trying to remedy those violations, and I'm trying to have enough money to settle this lawsuit. The ADA at the federal level, because recognizing this goes on all over in other states, not all over the country, but in states that have statutes similar to ours where they can get those damages. Two bills have been introduced at the federal level, one in the House and one in the Senate. And those created, although they're not moving quickly, they're sort of stuck just like a lot of other legislation at the federal level. But the idea is to create a notice and cure period. And Senator Flake introduced the bill in the Senate. It's a mirror bill of a House version. Basically, it would create a 60-day notice period and a 120-day cure period. They're moving through the process, but not at warp speed. So in an effort to resolve it, last year the legislature successfully passed something similar but somewhat different. And in Arizona, there is also a notice and cure period, but the notice period is 30 days. So somebody comes in and sees the parking lot is not in compliance. They are required to send the business owner a letter, and once they get that letter of notification, they have 30 days to come up with a curative plan. If that curative plan requires a building permit or some kind of license, then the 60-day period to remedy the violation is told. So all in all, there's 90 days. There's 30-day notice period and then a 60-day cure period with that time told if you're waiting to get your permit. During that time period, once it's completed, the property owner then needs to notify the plaintiff that they've come into compliance. But this legislation went beyond just the notice and cure period. It also tried to remedy the situation of the vexatious litigant. So a couple of things were added into the bill that put more teeth so that courts can do more. Basically, now if a judge sees that there are a number of cases by the same plaintiff and thinks that it might be a vexatious litigant, they can consolidate those cases and they can look at what this particular attorney is doing, and they can sanction them if they determine that it's really done sort of to shake down the defendants and get a quick settlement. It also allows the people who own older properties to bring their building into compliance. If it's 10 years or older, there's now legislation that passed that, and that this is separate legislation, but another bill also passed that allows people that have owned a property that is 10 years or older and has been in continuous operation, say you've got a restaurant, to go back and remedy those things, providing it's doing the same thing that it's done, it's been in continuous operation as a restaurant. And the idea there is also to give people an opportunity to make changes, but what's unique about that second bill is that it also allows people to bring in interpreters, to create other types of, say, digital apparatus to allow the visual or the hearing impaired to better access the premises and to utilize the services. So you can do things like that as well. And you can get a tax break for that. That's the biggest part of that bill, is it allows, at the federal level, you can claim a deduction, and now at the state level you can as well, if you are doing something to remedy that property that's been in existence for 10 years or more. So those are a couple of the things, and I just want to make sure I didn't miss anything. Oh, the third one is, and this is just a minor bill, but it's an example. So bingo establishments also can now provide digital equipment for people who want to play bingo. And I mention this because it's an example of an industry trying to go in and change the law to benefit their industry. So they're no longer in violation, but now they have this technology that they previously were prohibited from using. So there are lots of ways that an industry can go in and decide, we have this problem, and it could be with any of the issues we discussed this morning. Maybe there's a way to tweak a statute or an ordinance to try and better fit the needs of your industry.
So the legislation you were speaking of just a minute, is that all still trying to go through committee?
No, that was all
It's
passed last year. All
Okay.
three of those bills passed, and it puts Arizona in the forefront, really, in the country. California passed a law 2 years ago now, and their law, which started out big like ours, really got watered down, and so it only applies to companies that have 15 or fewer employees, that has under $1 million in sales, and it only gave them a very small window of notice and cure. What's really unique too, and I want to mention this because we're going to touch upon it later, but it also deals with websites, and that is a critical area. Arizona's bill includes a provision that says it does not apply, that the ADA does not apply to websites in Arizona. Unclear that that's going to be upheld by the courts, but for the time being, suits cannot be brought if they're based on a violation of the ADA for websites not complying.
If you are unfamiliar with the litigation, the Attorney General action that took place last year on the guy who filed over 1,000 lawsuits, we have those documents, both the court documents as well as the Attorney General documents at wemargad.org. You can look under state as well as regulatory. We also, the law that Alexis just referred to, we have that on the website as well, wemargad.org website, and that's going to be under state as well. So, and that's under judicial. So state and judicial for the law that was passed, or and then the other documents for state and regulatory. So you can find those documents and find those pieces and link right into what actually happened if you want to read more about what that background is. So as long as you mentioned the websites, let's go to websites versus brick and mortar and some of the things that we need to.
Right. So, there was a case that was, so this is an issue. The circuit courts in the United States are split on websites, and what the issue is, and it arose with a case called Federation of the Blind versus Target. So Target, previous to this case, the understanding was that the ADA applied to brick and mortar. If you had a store and you had to make reasonable accommodations for people to come in and utilize your services. Websites were not clearly within the purview of this, but the court in the Ninth Circuit in this case said that Target, because it has a website that allows people to access the products that are in their brick and mortar store, creates a nexus with that, and basically they are now under the guidance of the ADA, and so they are required, the websites that link to a store that is brick and mortar have to comply with the requirements for any type of disability, particularly visually and hearing impaired individuals. That case has now been, that same topic has been litigated, and there's a split. There are 3 circuits that have said yes, it applies to websites, and there are 3 circuits that have said no, it does not apply to websites. As a result, we're left with a situation of, how do you advise your clients? And we would take the standpoint that you should comply. And let me turn it to Bruna now.
Yeah, and just to back up just a second, just to clarify a little bit. So under the ADA, the websites are always covered. I mean, so we talk about that.
Right.
So the and what the Ninth Circuit said, it's a little bit more restrictive. So the Ninth Circuit says that the only time that websites are covered is if they're connected to brick and mortar.
Right.
Okay. And so that your website, so if you have just a virtual, if you're only providing services under a virtual situation, that it wasn't covered. There are a number of other circuits that say, yes, you are covered even if it's only virtual. So the Ninth Circuit, strangely in this situation, is more restrictive. So it's kind of better for, if you want, for businesses in this situation. So we're in the Ninth Circuit. So for you right now, if your website, right, is related to what you do, you have an actual building, right, your brick and mortar, where you are providing your real estate services, and your website is an outgrowth of that, then your website needs to be accessible, okay? If your website were the only place that you were providing your services, then under the Ninth Circuit law, you would not need your website to be accessible, okay? And I just want to be clear on the state law. The state law said that they can't file a lawsuit on website accessibility under the state law, but since federal law always trumps, not to use that term, but always overrides, right? State law, okay, is over state law, then you can still be sued under the federal law. Okay, so I would not hang my hat
Right.
on the fact that you can't be sued under the state law.
Right.
Okay.
And with that split in the circuits, it is possible too that the Ninth Circuit would expand the requirement that it's for all virtual businesses.
Yes,
So
yes,
it's better to err on the side of caution and comply.
And so what kind of things do you have to do to your website?
Okay, let me repeat that question for people who didn't hear. So the question is, what kind of things do you have to do to your website in order to comply?
Do you want to do it? So to make your website compliant, you are, because you are places of public accommodation, okay, you are considered a Title III entity, and this is the bad news, there are no rules that are yet in place. So what they do is they look to Title II, okay, and it's what is called WCAG 2.0 and 3.0. Okay, so you can have your people, your IT people look at either one. You have to comply at least with 2.0 to be best practices. And what that means for regular people like me who aren't IT people is that you will have like font will need to be bigger. We'll be able, not just so that someone can do it themselves on their computer, but if they're actually looking at your website, there will be a way that the font will get automatically bigger, right? If they want it to, there'll be a tab or something that can make the font bigger. There'll be high contrast in everything that you show. If you have videos, anything that is visual, that it will also be provided to somebody in audio fashion. So, or in, and that if it's in audio fashion, it'll also be closed captioned. So things of that nature, and that your websites will be usable by someone with a reader. Okay, so, and these things, while they sound more complicated, are really not expensive to do. It's some basic coding, and usually you can get someone who can get that basic coding. It's on a number of different websites, and I can, if you don't have it, I can provide that information to you.
Terrific.
And you can get your IT people to put that in there, and then they become accessible. So it's not that.
For our industry,
Yes.
so this is where some of our confusion comes in. I have a brokerage,
Yes.
and my brokerage has the website. They have a brick and mortar building, so they
Yes.
definitely have to comply. Two scenarios. I'm an agent within that brokerage, but I almost never go to the office. My world is outside of that. I meet my clients in their offices, at Starbucks, at the kids' ball games, whatever it is. So I very rarely go, if ever, go into the office. I'm running contracts out in the field and that type of thing. Parallel to that is I'm a small broker, and I don't have an office. I am always out in the field. So for those, either agent or broker, where's their website compliance?
How do you
issues?
use your website?
It would be, so for most agents, it's going to be, here's who I am. I help you buy or sell or both real estate in these areas. Call me. They may have a MLS search on their agent website, so you can sort of search the MLS and available properties if you choose. A phone number, email access. Here's how to contact me. So
Okay.
just generally
Are your
speaking,
forms on there? Are any forms on there?
I would
Anything
say,
like-
I would say the vast majority of agents don't have forms at that at that
Okay.
introductory.
So it's just basically
basic-
your front
It's your
page.
front facing, here's who I am type of thing.
Right, so those are really, that part should be, accessible, but very easy to make accessible. I mean, that's just
Okay.
a contrast issue. There's nothing
Okay.
really interactive about it, except maybe at the bottom, your telephone number that you have. Somewhere, if you're calling your brokerage or whatever else, you want a TTY, TTD number
Okay.
kind of thing, right? So someone can call in if they need to. If you have something at the bottom that maybe nothing else that says if you need a reasonable accommodation, right?
Okay.
If you need assistance, please call and refer them to that number.
Okay.
So you have something like that. Make sure that everything again is in high contrast, in a big font if they need it. Yeah, I mean, so if you don't use so if it's not very interactive,
Yeah.
it's really basic.
So
And
even
you
if
don't-
you're an agent
Yeah.
and you don't do a lot of business inside your brick and mortar brokerage, or if you're a small broker and you just are out in the field, you still have to look at those items for your
It's
website.
really basic.
Well, and a small
Yeah.
thing is the color red. You can't use the color red, which is a color a lot of people like to use on their website. So when they're selling.
Especially when it's part of your logo.
Right.
There's brokerages where that is their primary
So that's
color.
something that, yeah.
So how does that work?
Well, you can't use it, but I mean, that's the problem.
Yeah.
But the key thing is what Bruna is really talking about is you want to get somebody who's done this work before. You don't want to pay somebody to do it who's not really well versed in this because they could miss something like that.
Can I just ask you why red?
It's hard for someone to read.
Yeah.
So
I
red
believe-
print.
Right, like,
But like it's part of my general logo, it's the background color, or it's a line that delineates section 1 from section 2.
right, like if your print is like red on black.
Okay.
Right.
Like I bet if you go, I'm just going to speculate here, that if you go to the Cardinals game,
Yeah.
you're not going to see that on there.
Right.
Right? They have used black and white or other colors like that, right?
For the
Because
print,
for the print. Because red and black is hard to read if you have any kind of sight issues.
It's hard to
So,
read.
yeah.
And that's one that
Exactly.
people typically wouldn't think
Yeah,
about, but
right.
that's how you
So
determine.
those
if
are
you-
those kind of things where it's,
Okay.
yeah. Yes.
You were talking about the website where you didn't use the brick and mortar. What if we use that brick and mortar all the time?
Only,
The brick and mortar brokerage, you are sitting in an office, that brick and mortar, then I would assume you have to comply.
yeah,
Yes.
so so the ninth,
Yeah.
so there's no doubt, if you use the brick and mortar and you use your website in conjunction with that, absolutely you have to have a website that's accessible.
So the company would have to make sure that that is in compliance.
Yes.
Yes.
And what you want you want to make sure your broker understands that their MLS linking for you should be accessible. Okay? Because that's really what it's going to be, is that the services that you're providing really are going to be linking to them, right? So, and it's going to be people going on to see MLS listings. So they need to be providing those in some way that's accessible for the buyer.
So is MLS, does MLS come to us fitting in with these?
So when you have the IDX, when you've had the IDX link or something like that, so if you're a broker or an agent and you have the link to MLS, is MLS coming to the agent, or are you, the agent, going to the MLS and saying, are you compliant? That's the
Is it compliant?
yeah.
Is it compliant? I have
Like-
not looked at it for that. I would guess that it may not be fully compliant. Only because I can tell you most law firms, just to throw us all under the bus, most people are not fully compliant,
Well,
or not even partially
we
compliant.
don't use red much. I know.
That's true.
Right, I mean, so you're not alone, and I'll take 2 seconds to jump in and say that, so the same plaintiff's attorney that was doing the other cases in state court learned his lesson from, well, he's not the lesson that you wanted him to learn, however. Unfortunately, some people, get more educated and better at it. So he has now figured out that if he can't file under the state law, so what was happening before was he was often filing, sometimes in state or independent state and federal court, and he was getting pushed down into state court, and so people handle it on the state court level. So what he is doing right now that is relevant to you is that he is filing in federal court. He is filing primarily just ADA claims, okay? So he doesn't do fair housing yet, but I say yet. He is doing ADA claims in federal court only. He has taken the position that you can get nominal damages under the federal statute. He's found a couple of cases that would argue that. So, and what he is linking is to websites, okay? So for any representation that is made about accessibility, so for your, let's say your multifamily housing, if you were to say that something was accessible and you put that on a website and he finds that it is not accessible, he is not only suing you for the lack of accessibility in that, but he is also suing you for state negligence and fraud claims. So it's a barrel of fun, okay? And he is, right now, he says that he has learned, so he's not going after, he says, mom and pops. Right now, it's all of the major hotel chains. So they have, we have a couple of them, and they have all the heavy hitters nationwide. who are taking these cases, but they are tough to get dismissed. So just as just fair warning, put things on your website, make sure they are correct. And this is when I say if you're linking to MLS or whatever else, if you're making a representation that something is accessible, make certain that it is, right? And then under the ADA for hotel, anything that fits into lodging, so your longer term situations, there is a requirement that you accurately represent what is accessible on the property so that the person can make an assessment as to whether or not they can want to lease the property in advance. So they should be able to look at it on the website and make that assessment. And so he is going after listings even on Expedia and Travelocity and all of those, Airbnb, all of that kind of. So just be aware that that is the new frontier. This guy he's gotten smarter. So sometimes we fix a problem and create another. See? Now you know. I have a question way at the back too.
Yeah.
The first one is, how does this apply? You're talking about brick and mortar public accommodation standards. How does that apply to the individual broker that works right out of his home?
Well, that was going back to the question originally. If you're just a single broker and you don't have a brick and mortar, how does this all apply to you and the website?
Well, arguably, I mean, if you had this issue, we could try to defend you otherwise, but arguably, the argument would be that your brick and mortar is your house.
That's what I was thinking.
Yeah. And that your website is how you provide the services that you otherwise would have to create in your house, right? That you would provide in your house. So instead of having people come to your office in your house, you're using your website in lieu of that.
The second question, thank you, that was good. The second question, it's not what I wanted to hear, but it's
Right.
The second
That's who I am.
question is, you were talking about having something in a listing that is not true.
Yes.
Error. So we have the mobile listing on our computer, on our
Right.
website. And somebody else has a listing that's got defective information.
Okay, so the question is, you have a link into the MLS. Your client looks at the MLS and looks at a listing, but the information on that listing is incorrect. What happens to you?
Right. So if the information that you have, right, that you control is correct, right, and so then you're fine. And that is where the law in that particular section provides you that protection. Where the law is, where it gets you in trouble is if one of your clients has a property and then they want to put it on, let's say, Expedia or something like that, right? So they list it, or Airbnb or whatever else, and they provide the information inaccurately to that third-party website listing, then they're in trouble for that. Okay?
So we're clear.
But you're clear.
But you're okay.
Yeah. And I think you had a question in the back. He answered.
You just answered
That
that.
is so handy. You always
Yes,
get your questions answered. See? It's so good.
Very well
Right,
done.
Yeah, very well done. Exactly.
Right. Some of our commercial agents serve small business. They need to be a resource for these clients. Which information sites or information resources should agents direct their clients to for up-to-date information on the ADA rules for buildings, communications, parking lots, animals, and other public accommodation information?
So basically, I mean, you've got kind of a cross-section. You have to be aware not only of the state laws, which I've just mentioned, the ones that recently passed, but also any type of municipal laws that interact, and then you've got the federal. So you have the three, and they all have different requirements. And in the instance of the parking lot violations, there was some of the towns have different requirements. So you think you're complying with the federal, but now Tempe says, oh no, they need to be higher, they need to be wider, whatever. So you really have to look at all three of those to determine what the standard is that you've got to comply with.
So when I was doing small commercial, I would just tell my clients, all right, you could spend the rest of your life trying to figure this out. Or you could hire an attorney who does this and will tell you when things are going on, particularly at the federal level where they change things and there's no sparkly lights or notifications or anything like that. You just don't know. So I will tell you right now, that was one of the things that I used to tell my small commercials. Just hire a lawyer who does this on a regular basis to tell you what's going on and then explain it to you, because there's so many conflicts. It's so convoluted. It's difficult to understand and it's easy to get confused. So that was just from what I used to do. Yeah.
There are a couple of websites, but I will tell you that I was having this talk with this gentleman before we started, is that a lot of what used to be available on government websites has gone away. So, take that however you want. The regulations are still there, the statute is still there, but now you don't have the guidance anymore. So, that's all handy.
Yeah.
But we have, so ada.gov is for the ADA, will give you, your basic information. And if you go under technical guidance, I always say these with big caveats because this stuff is not easy to parse through, and there's outdated information on there as well. So you could easily look on the old parking as opposed to the new parking. But if you are bored and feel like going through, that's where you would go, okay? There is the same thing under HUD.gov, has the fair housing rules. The National Fair Housing Alliance is really quite good in collecting all the information on fair housing that is out there. And there are, kind of a sundry, and on accessibility, I would point you to Fair Housing Accessibility First. They are really quite good. They have frequently asked questions. Those will probably answer most of yours. They're pretty good on that.
I want to mention one thing too with regard to if you're selling a commercial property.
Yeah.
This is something that Bruna really specializes in, but you want to have somebody come in and look at your property to see, as a buyer, not as a seller, I'm sorry, but as a buyer, to make sure that it's in compliance, or that whatever changes you think you're going to make are going to be in compliance. Because a lot of times people hire a contractor who says, yeah, I've done ADA compliance. Well, he's done it in Mesa, but not in Tempe. And so, or he's done it up, north, but not in the valley. And there are such different requirements. And so you get in and you've got your certificate of occupancy. You think you're fine. Well, there's not enough inspectors to make sure that all of the outlets are at the right height. There's so many small things that they just don't check for all of them. And then if somebody comes in at the establishment, now it's not ADA compliant, but you thought it was because you paid this contractor to bring it up to code. So this is an area where you really want to pay attention and make sure that if you're
Is there a place we can go to make sure we can get a good ADA compliant?
Question is, how do we find a good ADA inspector?
Consultant or
Or
contractor.
contractor?
There are some, that is what I would, there are some good contractors. I would call your attorney for that and go through them. If you're hiring an ADA consultant, more often than not, you want to hire them through your attorney to maintain privilege if humanly possible to do so. And I would make sure that all of your contracts, when you're buying and selling property, if you're the buyer or seller of commercial property, that you have ADA language in your contracts to make sure that that's covered. Okay. Because I'm seeing a lot of very, very, very large commercial properties that don't have that coverage.
Wow. Okay, great. Thank you very much. So let's go to the physical accessibility to what the heck?
Well, why not, right?
Homes, condos, apartments, commercial buildings. That's always a concern, no matter who we are. Are there minimum accessibility rules for builders or people who rehab homes or condos, because we have a lot of rehabbers that are our clients, when they are for resale? Are there minimum accessibility rules for those same things when that project is leased?
Yes.
Okay, so.
Yes.
And we're going to cover apartments in this and everything. So give us a quick because it's so detailed. Sort of what do we need to be highlighting for our clients when they go in to do these?
You want some? No? Go ahead.
I'm trying. I'll let you start, then I'll chime in.
All right, you done? Okay. All right. So, and you want to do first, you want ADA or you want ADA and fair housing, both? Those are different.
Well, let's do ADA because we're on the commercial side of the fence right now, and if we
Okay.
have time, we'll switch over.
Okay. Well, because you have commercial on the other
Yeah.
side too. Okay. So under the ADA, there's ADAG, right, which are your requirements for accessibility, and that is the easiest. No one here would possibly want to learn all of the requirements, right? So if you're a commercial entity, if you're building just as a private entity, you're under Title III. If you are building with public-private money combined, you have Title II and Title III requirements, okay, for accessibility. They are very similar. Title II requirements are a little bit more stringent in terms of how they're applied. The easiest way there are technical guides. I'll tell you that. I mean, so if you go to ada.gov, you can download what those requirements are. If you would look at what your specific building is, so if you tell me, for example, you're building a townhouse or condo, there's one type of requirement. If you are building a small hotel or something like that, there's a different type of requirement. And there are checklists that you can follow. And so it is probably worth a quick call even to a somewhat expensive lawyer to get the appropriate checklists. Okay, you can go to those websites. That's what I would steer you toward. But the best way to think about them is that you start from the outside of your building. Okay, and if you just want to think about what the regulations are, you are starting from the outside. So you start from like your parking, right? So you come into your parking area. There are rules regarding the number of accessible spaces that you need to have. So not only are there the number of accessible spaces, but where those accessible spaces are located. They need to be dispersed, and they always need to be closest to the accessible entrances. There are there are rules as to how many of those spaces, depending on how many you have to be van accessible. Those are in ratios. And then, so that means how wide they have to be, in terms of how the striping, what the symbol is in the middle. It's usually, the wheelchair symbol. And then the signage, for example, that it has to be 60 inches off of the ground, and that if it's a van accessible one, it has to have, the van accessible sign has to be down below the other sign, and the 60 inches is measured from the bottom of the sign, right? You really don't want to go around with this in your head all the time. You want to have room for other fun things in your life, so just get the checklist. So that's like for parking. Then you go inside the doors, right? So your doors have to be wide enough for a wheelchair to go through. So you're going to have a 36-inch, for example. It has to have a 32-inch wide for a person to be able to go through. You're going to think about your handles. And this is just if you start to kind of get your mindset, so that your handles have to be something that you can either push, you look at your doors like that, or that someone can use with a closed fist. So think about someone not having use of their hands necessarily, so that they're able to open it with a closed fist. They can put it in and they can push down. So knobs, you see that those aren't around anymore for that reason. People can't grip. Okay, so that gets you inside the door. Then you have an accessible pathway. An accessible pathway will be everything from your parking area all the way through and around your commercial building. And that means that you're going to have something that is wide enough, so 36 inches wide typically, is so that a person in a wheelchair can get through.
And if they have
Right.
a dog, you need
Right,
room for the dog as well.
room for the dog as well, right? So that's how you kind of think about it. It has to be firm and not slippery, and it has to be so it can't be something that is bumpy. So it's got to be pretty flat. And so there are rules about that. You can't have gradations that are different than you can have a 1/4 of an inch that is okay. When you get to a 1/2 an inch, it has to be more than beveled. It has to be actually sloped, and that's what you'll see like at the entryway of doors. Because if you think about it, when we talk about like a 1/4 of an inch may not matter much when you're talking about signage. The height of a sign, we can say, okay, that's a technical variation. But a 1/4 or 1/2 an inch at a door makes a big difference, because someone in a wheelchair actually can't get in if you have an extra high lip there. So it's those kinds of things. Then, you get actually in and around. You think about where the seating is, for example, so, is seating able to be moved? Because that's important. And is the seating, what the height of the seating is. And so if you go into a restaurant, I'm amazed at how many new builds I see. And that was a lot of the lawsuits where all of the seating is in high tops, for example. Well, so where does somebody else sit, right, who can't get into a high top? And if you have a bar, you always want to have integrated seating, because, someone who comes in a wheelchair or who's using a walker or something else like that doesn't want to be sitting off in a corner by themselves, right? And if you're going in with a party of, you're going in with your whole family, someone's, in a wheelchair or using has some other mobility impairment, you don't want to be stuck somewhere else. So you want everyone kind of seated together. That means that you want to have some options, maybe at the bar area, maybe, over in the other seating. So it's those kinds of things. And then if you get into all the specifics about, like, how high your plugins need to be and all those other good things. So there's a ton of requirements. Restrooms, are always a lot of fun.
One.
It's a huge one.
Big one.
So you have, sinks, you have to be able to roll under them, you think about that, right? Or else have a parallel kind of access. You have where your grab bars have to be. Again, the reach, so things like that. So again, it seems like a lot. It becomes almost intuitive if you just put yourself in somebody else's shoes, literally for just a little while, and kind of think about, what would I need, right? What might I do, And my husband says I'm the ADA police, and I go around with him, and I'm like, this isn't compliant, that's not compliant, right? Should I call them and tell them, right? I'm a lot of fun, right? you can always take me to dinner, and then I can tell you, right? You have a question over here.
So with commercial buildings, if there
Yep.
are several different entrances and they all go into like the same common area.
Right.
Does every single entrance door need to be compliant? Or
So the-
one door?
So the question is, if you have a commercial building with several entrances, does every single entrance need to be compliant?
No, the general rule is 50%, and it depends on where they're located. Okay, so it is at least 50%, and then it goes up from there. So, and again, it depends. Like if you have a strip mall, right? So it's really spread out. Then you need to have more accessible doors because someone, parking way over here, you can't have it over there. But if it's really is done more in a more compact area, then you're okay with having fewer accessible doors.
And again, you want to
Yeah.
make sure that you're complying with all three levels, with the federal, the
Right.
state, and the local, because the local on any of these could change the.
Yeah. So for example, the city of Phoenix has your parking is universal parking, unaccessible parking, so it's much wider. So all of the parking is essentially van accessible parking for the city of Phoenix. So, and most people aren't in compliance. So,
I found something interesting. This is just a fact. I had a gentleman that made signs for hospitals.
Mhm.
They required them to be put in Braille
Mhm.
also.
Mhm.
How can they find the sign?
oh, those are actually that's an actual easy one. Yay!
Good.
See, I
So
like
for those
easy
who
ones.
didn't hear, this has
Yeah.
to do with signage, and she was speaking about hospitals who have the signage in Braille as well.
And actually, that's all commercial buildings. So any, in hotels, hospitals, rooms, we'll call them, any area that has a designated function, that's what I'm looking for. So a bathroom, an emergency area, something like that, needs to be signed so that it's also in Braille or it has the pictogram or something like that, so that a person knows always, where they have to go for those kinds of things. If other functions don't need to be in Braille, so some things do, some things don't, but you do have to have signage. So signage at the front of buildings telling people, if you have, this also goes to the other woman's question, if you have non-accessible entrances and you have accessible entrances, you have to have signage pointing where the accessible entrance is. Okay, so you can't
There's
just,
something that
yeah,
tells them
where it is,
to
yeah.
find.
Oh, and so where you find them is, they are online and they are at any of the major signage stores.
At this facility.
Yes.
Right.
How do they know where the Braille signs are? The actual.
Is she saying how do they
How does
identify
a blind
that
person
it's there?
know, how does a person who's sight impaired know to go there? Well, typically there's a series of signs that will get them to that location.
The wall, is that what
Yeah, like, if someone says, where are the restrooms, there will be like other signage that says, accessible restrooms that direction, or just restrooms that direction. And because if all the restrooms are accessible, then you don't, and that sign will be in Braille or will be lifted, just so,
I'm just trying to figure
yeah,
out how they find that Braille sign.
Yeah.
That's what I
Yeah.
don't understand.
How do
Yeah.
you find the one sign?
Yeah,
Yeah,
right.
yeah, that's
I
exactly.
can't see a thing. Where's the sign?
Yeah.
Can't find it.
Well, I mean, again, it's like, how you find any bathroom. I mean, it's like, it's
One
a,
wall, wall touching it?
You'd have to go down.
you
the-
ask, right? I'm saying, where are the restrooms? I mean, that's what
Yeah.
most people do, right? If you're looking for a restroom, things like that, yeah. And then but the big thing is so that they can tell if it's a male or,
Once they're traveling down the right
Down the-
route.
yeah.
Once they've found it, then they,
Yeah.
yeah.
They're there.
and if there's far away, like in casinos and things like that, we put in different signs along the way so they can find them.
Okay. So, going
Yeah,
back.
I know,
right.
you can always have more signs than less if you're,
Going back to the building and those different changes and accommodations, is there a difference in the rules between a building that's like a 100-year-old building and a new build? Are there different parameters?
Well, this is the law that was passed just last session, and basically what it says is if you're 10 years or older, then you can try and then you can deduct the cost of bringing that into compliance. As long as there's one
Arizona.
caveat, in Arizona, and as long as you have not already been sued. You can't have received a notice letter that you're out of compliance. If you're doing it on your own volition, then you can deduct the cost of that, which is a huge savings, as well as take advantage of adding additional things and deduct those costs. If you decide you're going to put menus or something else in some kind of form of technology, so that it's easy for people to read.
And so for the other parts, for the federal law, it is, so the law went into effect in 1991, right? So, and it applies to new construction after March of 1991.
Right.
And so that means that you were either had to be in compliance with the 1991 requirements, or now there are the 2010 requirements. And if you were in existence prior to 1991, then the standard that always applies is readily achievable barrier removal. And so that is what, always comes, and that's really where the state law then kind of kicks in with the same thing, which
Okay.
is where you always need to be trying to remove the barriers. And so in the areas that I was talking about, like when you first enter, how you go, and then the bathrooms, those are, there's a method to my madness. So those are those are the basic areas that they look at
Okay.
when you are trying to do readily achievable barrier removal, because those are kind of the big things that you
So in the
look
federal
at.
law, when they say readily achievable barrier removal, then we really need to start looking at state and local in particular to see what they may mandate that particular thing be. So that's how they sort of coordinate together when we sort of get a vague phrase like that?
No, readily achievable barrier removal is a federal standard.
Right.
And the federal law applies. It means that they look at first they look at accessible pathways.
Okay.
So, for you're getting in, and then they look at your access to goods and services. So whatever
Okay.
is there, they look at your bathrooms. So they have their standards as to what is
Okay.
readily achievable. And readily achievable means something that's not an undue burden,
Okay.
which it goes to how much money you make, right? And it is compared to that, so how much you're spending there. And also whether it fundamentally changes the nature of your business, okay? So those kinds
Great.
of things. And then you layer on top of that
Okay.
the state and the local.
Great. Okay, our time is up for this section.
Darn.
So we're going to take a 10-minute break and come back for Disparate Impact.